This program is made possible by the New York law firm of Zalman and Storman, who specialize in the field of personal injury law. Welcome to Law Line with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Law Line will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Law Line. In 1969, more than 1,000 arrests were made in New York City for rape, but only 18 cases resulted in convictions. Since that time, legislative reforms and new investigation techniques has increased the success rate in the prosecution of sexually violent crimes. Despite dramatic progress in the way courts are treating rape victims, sexual assault crimes are still the most underreported cases within the criminal justice system. Today we'll look at that issue with our guest, Linda Fairstein, Chief of the Sex Crimes Prosecution Unit at the Manhattan District Attorney's Office, and the author of the new book, Sexual Violence, Our War Against Rape, and Louise Kinley, a social worker with the Rape Intervention Program at St. Luke's Roosevelt Hospital. Hello, Linda. Hello, Louise.
Hi.
Linda, basically tell me, what is your book about? Why should the public read your particular book?
Well, I think because there's nothing quite like it. My book is an attempt to explain to the lay reader who is not familiar with the criminal justice system what the changes have been in the last 2 decades, because I think most of the information about sexual assault cases and the way they progress through the system is based on old laws, what I call myths that persist because our laws were so bad for so long. There has been an enormous amount of progress, as you said in your introduction, in the last 2 decades in every aspect of this work. It's not perfect yet. We have a long way to go. But I think there is some better news about the way these cases progress through the system and the fact that victims can win if they can get into the system and access to it.
Louise, you work basically in a crisis program. Tell me, what do you do and how do you help these women who have been abused sexually?
Well, of course, the women that we see come from all over the city and come to us in many different ways. A lot of the women that we see come through our emergency room. Those women tend to have been brought in by the police.
That's at Roosevelt St. Luke's?
Both Roosevelt site and the St. Luke's site.
Right.
And when they're brought in by the police, that usually means they have reported the crime. Not always, but usually, because rape is not a reportable crime. People don't have to report it. Many of the other women that I see come in through other avenues. And part of the process of therapy is dealing with the emotional pain, but also helping them understand what their options are in terms of reporting and prosecuting, and understanding what that process would be like.
Well, how does reporting the crime, how does proceeding with the prosecution, how does that help the victim emotionally?
Of course, when you have been brutalized by a crime like rape, one of the most healing things is to be able to say in public, this happened to me, it was wrong, and this person is going to jail because of it. Often that isn't what is going to happen. Often that can't happen. Not that the crime didn't happen, but that there may not be enough proof to show that that happened. And that's why our relationship with Linda's office is very important to us, because I can send a woman who is not sure what would happen if she reported to the crime to talk on an informal basis in terms of what would happen if she chose to report it and what the chances are that she could go ahead to trial and possibly get a conviction. Of course, there's no guarantee.
Linda, if a woman comes to you in that confidential relationship, you're not going to force her to prosecute if she doesn't want to.
Of course not. Absolutely not. And one of the, as Louise says, one of the wonderful things since units like Louise have come into existence, they are wonderful means for the victim to get into the system and to get information from a very supportive advocate like Louise and her group and find out whether the system can help, whether the case can be won. Most people still come to us expecting that it can't be, and it's quite wonderful, as Louise says, when the victim can identify an attacker and triumph over him in the courtroom. It's very cathartic.
Let's talk about how the law has changed.
Okay.
What was it and what is it today?
All right. The single most important change is something called the elimination of the corroboration requirement.
What does it mean?
And that means that before 2 decades ago, when I came to this work, the law required more evidence than the victim's word to go, literally, for her to set foot into a courtroom.
Another eyewitness?
Practically, it required proof of the identification of her attacker. And many crimes, as you know, occur in broad daylight with witnesses, bank robberies, muggings, and it virtually required identification by someone else of the attacker, proof of the sexual nature of the attack, and proof of the kind of force. So if a woman wisely submitted to the threat of force or threat of a weapon and didn't have injuries, there was no corroboration of the force. So most women were barred from ever setting foot in a courtroom until the mid-70s in this state. I mean, it's a shocking fact. And
so I assume that would include date rape if somebody went on.
Especially date rape. I mean, the stranger rape, which often occurred with a weapon and sometimes with physical injury, victim had a better chance of getting in the door. The average date rape, where there's rarely physical injury, it's not an element of the crime, it's not required, and often not an immediate report and not an outcry. Those women just literally were barred from the system as in no other crime. It was the only crime in our system that had this impediment, and we inherited this from an English case opinion that was written in 1671. I mean, it remained a part of the laws in this country for 300 years, and still, probably Louise's experience is like mine. The overwhelming number of women who walk in my door today say, but all you have is my word. I mean, there's no other evidence but my word. That's all that the law requires. As it does in any other, today, finally, as in any other crime. I mean, that word is the subject of direct examination, of cross-examination. That's what a trial is all about in every case.
Louise, the women that come to you, do they feel that they're going to be put on trial and
Absolutely.
you have to overcome that?
And the other big change in the law that very few people know about, and that unfortunately I think television tends to reinforce this myth, is that if you choose to prosecute, your entire sexual history is going to become common knowledge in a courtroom.
The people you've dated for the last 5 years,
That's
and
right.
they'll bring them in and talk about
Your sexual
your
activity.
performance.
Exactly. It's anyone that you've ever had sex with for your entire life. People do not know that that also has changed, and that a person's sexual history can only be introduced into evidence if there has been a sexual relationship with the defendant. Is that correct?
Right.
Or if the woman is a prostitute?
But only under even limited circumstances in that regard. We had a case this week where a crack addict victim said to us very candidly, this case is going to be a problem. I used to be a prostitute. I have convictions through 1988 for prostitution. I don't do it anymore. The law even protects her and says only if the prostitution convictions have been in the last 3 years. So she can't even be asked about that, she was surprised to learn. The point is, as Louise very rightly says, that's the other most significant change. And it's called the Rape Shield Law. And interestingly enough, my experience again is the same as Louise's. Most victims come in and aren't aware of this change and say things, well, I saw in such and such a case on TV or on the news that everything about this woman's past was revealed. Interestingly enough, the media often explores and reveals those kinds of facts in high-profile cases, and yet they would not be admissible in a courtroom.
Linda, let me ask you this. Let's assume a couple is dating, and they're going out for months, and they're having sexual relations. And then one day, the one party says, no, not today. And the other party goes ahead anyway. And it forces his intentions. And I'm assuming it's the male with the female, because that historically is what happens. Well, what happens then? What should she do? How does she prove her case?
We could go on for hours about that hypothetical, because you've probably picked the most difficult example of a case that obviously of a case that could go forward, either a domestic relationship, a marital or long-term sexual relationship. Obviously, our law allows the victim, a woman usually, to say no at any point in the relationship, and if the defendant uses force or the threat of force, we still call it rape. It is clearly harder to prove that kind of case, assuming that there is no injury, that he has committed the act by some kind of force without injuring her further. The easy case, and I don't mean this facetiously, but an easier case would be if he uses so much force that he hurts her in a way that leaves evidence.
She says not tonight.
She says not tonight, and if he says, you better do it tonight or I'm going to kill you, that's the toughest
Something
example.
short of that. I mean...
Something short of that may or may not.
She just, something short of violence. In other words, what's the level? What level has to be reached before a sexual advance becomes rape?
Okay, the law defines it very clearly as forcible intercourse, or rather, intercourse by forcible compulsion. And forcible compulsion is further defined in the law as threat, express threat, or an implied threat, which places the victim in fear of death or of serious physical injury. There's a less serious form of the crime, a misdemeanor called sexual misconduct, which is intercourse without the consent of the victim, which may be where less force is used. Those are the harder cases, Alan, but they are also the much less frequent cases. I mean, that's not going to be the experience that most people come into the criminal justice system with, and especially in the long-term relationships, those are often the cases where even though a victim might report the case, she might withdraw from it 2 weeks later because she wants to resume that relationship, which is the hardest part of domestic violence cases. But technically, she's entitled to enter the system if she has been the victim of a forced attack.
Linda, what is the statute of limitations? Is there a period of time that if a woman waits, she can no longer report this crime?
She can report it, but the law can't do anything about it. Yes, so the statute of limitations on felonies like rape and other forms of sexual assault is 5 years in New York State, and in most states something like that. And of course, I think, and probably Louise would agree, for one's own well-being, I am an advocate, as I say over and over again in the book, to report for a variety of reasons. I think the first thing, whether or not a victim wants to make a police report, is to get medical attention, to get to a hospital, to be examined, because often the victim isn't aware internally, can't be aware of whether or not, because she doesn't see bruises, whether or not she's sustained any damage internally, whether or not she's been exposed to a venereal disease or infection. So I think it's important to get help. And secondly, counseling and psychological help, because recovery doesn't happen in this category of victimization by not dealing with it, or by thinking if I just don't talk about it, it'll get better. It doesn't.
You stimulate another question I have. Let's assume the person has AIDS. Mm-hmm. And doesn't inform you of AIDS or something of that nature. Is that a higher level crime?
No, at this point in New York State it is not. We don't have penalties for that kind of thing. There are states that have made sexual assaults. I mean, I don't know if you're just talking about acts of intercourse where people haven't communicated. That's not a criminal issue in New York, but we don't have that kind of law here.
Just so I understand this, a person has AIDS, I'm under no obligation whatsoever to tell you that I have AIDS before we have intercourse.
That's
the law in New York State?
And there's no criminal obligation, whether you have a moral obligation to communicate that.
Well, I may be putting you in terrible, dire circumstance.
That's right.
And I have knowledge of this.
Well, it's to my knowledge, it's not a crime that I'm aware of in New York.
Louise, what if a woman was assaulted months or years ago and she never came forward, and she's been harboring this and it's changed her life? What would you recommend for her?
When we're talking about a crime that occurred years ago, and certainly I see a lot of clients like that, I've never had anyone who ever considered legal steps. At that point, it is always, or at least in my experience, has always been a counseling issue. If it's been months, then we may consider that. It's certainly an option that she has, but very often when women are raped, and again, I want to make the point that 75 to 90% of rape is acquaintance rape, meaning that people are raped by people that they know. Those are the women that are least likely to go to the hospital right afterward, to the emergency room, are least likely to talk about it or deal with it in any way. And then months later, when they really can't function anymore, that's when they come into us for counseling. Or perhaps they do push it down, get on with their life, and then it comes up years later, maybe when they're thinking about marriage, or all kinds of triggers can bring it up. At that point, it's always first emotional counseling in terms of how they are dealing now, what's going on now. Legal options in those kinds of cases are things that we explore only after the person has begun to open this up a little bit and we see how it's been affecting their lives.
Do you see victims of incest as well?
Yes.
And what's your advice regarding that, as far as a crime or not, or reporting it or not?
Well, of course, that's an area of law that's really changing right now. In California, they have the law that you can prosecute in civil cases, and I think in criminal as well, I think 5 years after recovery of memory, because many people suppress this and don't remember it until they're adults. There is a bill like that in the New York State legislature, and I don't know what's happening with it right now.
What's your advice to the women who are watching this show, to the men and women watching this show,
Yes.
regarding incest?
To get help, to go into therapy. This is such a devastating crime. It is such a common crime, unfortunately. And right now, there really is a backlash in this country in terms of the False Memory Foundation, who is saying that therapists induce false memories. So people are becoming afraid to go into therapy because they're seeing therapists as people who will talk them into believing that things happened that didn't really happen.
Linda, we have to take a break now, but I'd like you to think about this question. Can a husband rape a wife?
Easy.
You're watching Lawline. We're talking about sexual abuse in the home and elsewhere. Stay tuned. I'm Alan Schnorman, your host.
After dating the guy forever, you think I could tell him anything. Why is this so hard? I'm really scared.
It takes a lot of guts to tell someone he's too drunk to drive. But you can do it. Just say it. Because if you don't, there may be nothing left to say.
Kevin, I'm gonna drive.
Take the keys, call a cab, take a stand. Friends don't let friends drive drunk.
When your employees train with the National Guard and Reserve, they learn to be better team players, better decision makers, and better leaders. It's training that makes them better at serving our country. And better when they come back to work for you.
Bill's back.
Be a hero. Give your employees the freedom to protect ours.
Hello, I'm Alan Schnorman, your host. Today we're talking about legal breakthroughs convicting sex offenders. With us are Linda Fairstein, Chief of the Sex Crimes Unit of the District Attorney's Office and author of Sexual Violence, Our War Against Rape, and Louise Kindly, social worker with the Rape Intervention Crisis Center at St. Luke's Hospital. Linda, right before the break, I had asked you, can a husband rape a wife?
Absolutely. For years, New York State, not a leader in legislative reform, did not recognize marital rape as a crime. That changed a decade ago when our Court of Appeals said that that was unconstitutional. But interestingly enough, and I don't know if Louise would agree, those cases, first of all, we don't see as many in the system as I'm sure occur, but there's usually a lot of violence that accompanies those cases. It's rarely rape without other injury, as most sexual assault between strangers actually is, because domestic violence is usually occurs with a lot of other battering and kinds of injury. So the victim who presents herself is rarely the wife who says, last night I didn't feel well and my husband forced me to have intercourse. It is usually a gratuitously violent situation with a lot of other injury. Right. I think Louise might agree.
Because we also see battered women at our unit, and most of them have been raped repeatedly by their husbands. That really is not even something that they focus on. It's the physical battering and abuse and the terror of their lives that they focus on.
And a whole pattern of abusive behavior, of which the sexual aspect is one part of it. And here again, the counseling units, the shelters, the services available that didn't exist a decade ago, and God knows we need many, many more than we have now. But that's an entire other subfield of sexual assault.
And there's also a legal issue there, because again, in New York State, and I think it's the only state that has this law, a woman has to choose whether or not to prosecute in family court or criminal court. If she chooses family court, she cannot take it to criminal court. Any other state, you can prosecute in, or you can have a case in both courts. And the woman has to decide, as I recall, within 48 hours.
Yes.
Linda, between a husband and a wife, do you ever have a situation where the wife wants to bring charges against the husband, but she doesn't want the relationship terminated? She has 3 children, the man supports her.
Yes, and I think that's what Louise is referring to, too. That's why often there is an option. She doesn't want him in jail, and often in those situations she's hoping that some kind of counseling or work with him will it's often a love-hate relationship. There's something in the relationship that she wants to sustain and maintain and salvage. And in some cases it can be. As you say, there are usually children involved and a whole family dynamic. And that's what I think makes domestic violence such an inappropriate subject for resolution often in the criminal courts, because there's so much bigger picture than a case where the 2 parties never saw each other before and never want to see each other again. I mean, it's easier to just say prosecution is the easy answer.
Linda, I know you were the prosecutor on the Robert Chambers
Yes.
case. I also know you participated in the Central Park jogger case.
Yes.
Both cases had worldwide publicity.
Mm-hmm.
What effect does that have on your prosecution and presenting it to the jury?
It always, as you know, as a lawyer, I think makes a nightmare of a case. I mean, it adds dimensions to cases that take it out of just the lawyerly work that you have to do. I mean, in every aspect, picking a jury, for example, becomes much different, because in both of those cases, the media saturation before the trial makes it very difficult to get a jury pool that hasn't already formed opinions about the case. So you lose a lot of your well-informed public that you'd like to be jurors, because they've read the newspapers, they've listened to the news coverage, and so you have that aspect of the case. You have witnesses who become reluctant because they don't want to be reading about themselves in the New York Post and seeing themselves on court TV at night. So every aspect of the case is very different when there is a disproportionate amount of publicity.
Question. Do rape cases, can you say, no, I don't want my case televised?
Yes. Rape cases rape victims cannot be portrayed on television in New York State, and that's a very good protection for them. And our victims are not exposed, nor can we, there's a new law in New York that people in law enforcement cannot give names or any identifying criteria to the media about victims of sexual assault. And since I believe that victims should themselves choose whether they want to name themselves and go public, I think that's an important protection.
One thing that I just wanted to say about the Robert Chambers case, because date and acquaintance rape are so much in the news right now, is that to me this is the ultimate example. I mean, this was a woman who was murdered, and still at the trial it was portrayed as simply rough sex that went wrong.
Well, you're right, he tried to portray himself as the victim.
That's right.
He was the one who claimed that he had been the victim of rough sex, and that this lovely, vibrant 18-year-old girl who very much wanted to be alive, who liked Robert Chambers, and who had a loving family and a lot of friends, it became, as you know, a blame the victim defense, and the most hallmarked one of its kind, in which this young lady was blamed for her own death by attacking this 6'4", 220-pound sociopath.
And if she had not known him, that could not have happened, I don't think.
Right,
I think it was
that's true.
simply the fact that she knew him and had a relationship of sorts with him.
Is that typically one of the defenses that in a rape case, a date rape case?
Yes, as I explain in the book over and over again, it's become a very tired one. I think one of the good things about the media attention to this crime, which is relatively new, I mean responsible media attention, is that people are learning that's one of the age-old defenses, and it's getting a little worn in the courtroom.
Now, I know date rape is now discussed on every college campus, coast to coast. In fact, I was just reading about Antioch College. Can you tell us about what's happening there?
Yes, and Antioch College this fall of '93, there's a movement to require a verbal contract between students in a dating situation, so that through every step of the relationship, the parties must ask each other and obtain consent. May I hold your hand? Yes or no. May I kiss you? Yes or no, as the steps progress. And it's become controversial, I think, in our communities because although I think it's very intelligent to educate college students and everyone else about the issues that involve acquaintance and date rape, I, for one, think this is a very unrealistic way to think that we're going to conduct our social lives.
Louise, and from your professional standpoint?
I think that it's very important that both men and women, but particularly men, understand that they should really be clear that the woman wants to have sex. I think that this kind of verbal step-by-step contract is, again, I agree, totally unrealistic, and also a way of clouding the issue, because the fact is most date rape is not a result of a misunderstanding.
So what is your advice to couples out there? I mean, how should they perform? How best to the young couples, to the college students, to the young singles, in the new age, and I call it new age because it's different. How should they perform? What's your advice?
You want to know my personal opinion?
That's exactly what I want.
I don't think things are any different now than they ever were. I don't think that the majority of men and women, young men and women, are going around getting raped and raping each other.
I agree completely.
I think there are a few, there are cases which are in that gray area. Most of them are not. But if you have raped someone, what are you going to say? You're going to say, well, she said yes and changed her mind. What other defense do you have?
I agree with Louise. I mean, I think that this still remains aberrant, dysfunctional, unusual behavior. I don't think it's the norm on campuses or in dating relationships. And I think it's very healthy. I agree that this has gone on for a long, long time. I think it's only in the last decade or so that we have been able to discuss these issues, which I think is a very healthy thing. And I think the more we continue to be open about them, aware of them, and educate and better socialize our young adults about these issues, we will come closer to addressing the problems more appropriately.
Linda, could you briefly take us through a whole rape scenario from the time that a victim comes to you through the trial?
Okay.
Briefly.
Okay. I do it better in the book.
In 2 seconds or less.
Okay. Well, a variety of different ways, but ideally a victim is reported to the police, been taken to a hospital, had an advocate intervene and explain to her explain to her
would be
what
a volunteer in the
her options
hospital.
that what will happen when she enters the system. Make the call. Perhaps Louise will call me and say, "Can you see Miss Jones this week?" And I will meet with her. One of my staff will. I'll explain and demythicize the criminal justice system. No, you can't be asked those questions. No, you can't be exposed to this. You will only have to be at a grand jury. You won't see the defendant there. You won't have to be in his presence. You will only have to encounter him at the trial. No, the defense attorney can't ask you these questions. Yes, I think the likelihood of winning the case is very good. I don't need any more evidence than your word. It would be lovely if there is additional evidence because it'll be easier for you. And yes, and I say 10 years ago I couldn't have said this, but I think there's a very good likelihood that we can get a conviction in your case. That's in a
And what
nutshell.
about percentage? What percentage of these cases actually go to trial, and what percentage of the perpetrators are convicted?
Okay. Serious breakdown between what we call stranger cases in the system, attacks on individuals not known to the victim, which are, as Louise says, the less likely occurrence.
1 minute left, quickly.
95% of those cases will result in convictions in the criminal justice system. Acquaintance cases, far less successful, still probably only 60 to 70%, because people who sit on juries need to be educated about the nature of this crime.
Would you like any changes in existing law?
I'd like attitudes to change about the crime more. The law's changed a lot. I'll take small reform, but educating your public.
Louise, would you like attitudes to change, and how would you like to change?
Of course I would.
Give me an idea. Quickly.
Oh, God. One thing that I would like to change in the criminal justice system, though I don't think it can happen, is that it was faster. Because one reason people give up is because it takes so long.
Louise Kinley, thank you very much for appearing on Lawline. Linda Fairstein, thank you very much for appearing on Lawline. And
Thanks,
as always,
Alan.
this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.